Good morning. Recently, you would have noticed one of the news about Soukku Shankar, contempt proceedings and punishment all. Some people wanted to be familiar by getting punishment from the court involving in grave offences. So many persons, for that they will have alias name, Soukku Shankar, Yanai, Punai, so many things they add their name to invite these tubers and WhatsApp groups, whatnot, Instagram also. Here, on another case, you see what had happened. AAR 2022 Supreme Court 3933, Mehboob Prasad Central Administrative Tribunal. Here, what had happened? Some original applications were filed before the tribunal. On 8/2/2019, when counsel was arguing, he says the tribunal member seems to have informed the council that there may be a imposition of cost of 25,000 driving you to Supreme Court. Then there was a bro beating, the chairman, and thereafter what had happened, the council seems to have informed the court that I want to argue in camera proceedings because I want to say something about the chairman. If he further said, if I say anything in open court, that may scandalize the chairman. But however, the tribunal's members wanted him to say whatever he want to say in the open court, but he did not. Therefore, the contempt proceedings was initiated against him. He was notice was issued and charges were framed on 10/2/2020. That time they have not produced the appeal memorandum and charges copies and other things. The lower court, they produced it only after receiving the lower court records. A draft charge was finally framed. Then he refused to admit, and finally they passed the order. The acts and omission on your part would only have the effect of tarnishing the image of the tribunal, but also amount to criminal contempt for threatening the presiding officer. You are hereby directly tried by tribunal for the aforesaid charge. Then the charge was denied. Then it was listed on 25/2/2000. They punished they say they have referred Leela David versus State of Maharashtra. Leela David versus State of Maharashtra, AR 2010 SC. And the council wanted a trial under Rule 15 of the contempt rules. That was not denied. His argument was heard and judgment reserved and punishment was given. The Supreme Court, after analyzing the entire rules, what all are the procedure to be followed when contempt is being initiated by tribunal as well as High Court and Supreme Court. They said the tribunal is not having that much of power as Supreme Court and High Court possess. But however, they say under Rule 15, except otherwise provided in the Act and this, the procedure prescribed summary trial under Chapter 21 of the Code. Code means Code of Criminal Procedure, as well as practice be followed inside trial of cases for contempt. Trial may either suo motu or motion made for that order the attendance for cross-examined person whose affidavit has been filed in the matter. They, however, direct discretion, direct any person to be examined as a tribal witness. And they further say they say the judgment based on the Supreme Court judgment Leela David versus State of Maharashtra. Still they say Section 14 contempt committed person face of the court. A trial may not be indispensable. They say the trial should not be indispensable. So they say Section 14 procedure says cause him to be informed of writing of contempt with which he is charged, afford him an opportunity to make his defense of the charge. After taking such evidence as may be necessary, as may be offered by such person, and after hearing, proceed either forthwith or after adjournment to determine the matter of the charge. Make such order for the punishment of discharge of such person as may be just. By this, they say it shall not be necessary for the judge or judges in whose presence or hearing offence is alleged to have been committed to appear as a witness, and the statement placed before Chief Justice under Section 2 shall be treated as evidence in this case. That was they say. However, they say they did not follow procedures. As far as suo motu proceedings for contempt are concerned, we are of the view that Arjit Prasad J was well within his jurisdiction in passing a summary order. Having regard to the provisions of Articles 129 and 142, although Section 14 of the Contempt of Courts Act 9 lays down the positive policy criminal contempt in the face of the court, it does not preclude court from taking recourse to summary proceeding when a deliberate and willful contumacious incident take place in front of their eyes and at public arch, including senior law officers such as Attorney General of India, who was then Solicitor General of India. Therefore, finally they say, we cannot possibly equate the tribunal with this court. Undoubtedly, tribunal is endowed with the same power as available to the High Court under Act, but conspicuously the power available to this court under Article 129, 149, 2 are not available to the tribunal. Therefore, they say they would have given an opportunity for trial. They said what happened thereafter, they remand back for appropriate, they set aside the order. Tribunal could not have derived support of judgment for reason already indicated. They also say, which is denial of right of trial is miscarriage of justice. Absolutely, we are allowing this appeal only on the ground of procedure under Act and rules which reduce to adducing evidence when there is denial was not followed. We would undoubtedly have had no reservation upholding order evidence to suppose charges subject to observation. Appeal is allowed. Impugned order is set aside. Needless to say, direction to forward the case to the Bar Council will also perish. The impugned order will stand set aside. This what had happened, and further they in the rules also says some third judge should hear the contempt application with the permission of the Chief Justice. That rules were also how to detain, how to release him on bail. All these things. They says rule 14(2) says where a person charged contempt of subsection apply, whether orally or in writing, to have charge against him tried by some judge other than the judge or judges in whose presence of hearing is allowed to have been committed, and the court opinion it is practicable to do so, and in the interest of proper administration application should be allowed. This is what they say. Okay, this is what Soukku Shankar. The problem is frustrated facing departmental charges. We used to follow a lot of these sort of irrelevant approaches. That is why that resulted these sort of litigations. And they are very proud. So many things had happened already. I hope you understand. Best